and that all of you came back refreshed. So as I promised, I'm gonna basically go over the exam with you right now and provide you with an exam review. The slides you see right now are gonna also be posted as kind of your study guide. We're gonna first go over the exam itself, the different components, type of questions you're gonna expect, and following that, I'm basically gonna go over in a bit of detail, kind of reviewing our lectures bit by bit. So hope you guys find this useful, and let's go ahead and start. So for the exam format, I did mention before I left, basically the lecture before, right before spring break, that our exam is going to be made up of two components. First is going to be, of course, the total time is 75 minutes. And we're gonna have a part one, which is a closed book exam. It's gonna be it's gonna be 15 questions. In reality, you're gonna see 16 questions, and you're gonna have an extra question that's offered as a bonus. So you can actually gain 2 points in bonus in this part. So this part is gonna be worth 30 points. You can earn up to 32 points by answering all 16 questions if you wish to, and you won't have a penalty if you answer extra or wrong. So I won't be grading negative. It's either 0 or you get the score. And the types of questions you'll see there are multiple choice, and also we're going to have a bit of true and false questions for you there as well. The second component, which is part 2, that's going to be an open book part, where you can basically open up your notes. If you wish to open up your laptop, that's fine. And basically you're going to have access to your notes and readings and your lecture slides and stuff like that. You can go ahead and look at those. The only thing that's you're restricted from is communication with others in the class using any means. If you have your laptop or iPhone, iPad on, you basically can talk to others using those devices. And I'm not going to be policing it, but again, the person who's going to be proctoring the exam, if they catch you, we'll pursue this till the end. We'll consider this to be a cheating case, and I really don't want to go through something like that. The questions there are also 15, so you're going to be graded at 15, but you still have 16 questions. Each question is worth 3 points, so you actually stand to earn up to 3 points of bonus there. So the total number of points you have on the exam where you can earn some bonus is basically going to be 5 points. So that's going to be 5 points out of 75. So as I mentioned, second component is going to be worth 45 points. You can actually score up to 48 points by answering all 16 questions. The questions there are going to be short answer questions, where you're going to basically have to provide a brief explanation of a concept or provide an example of a concept that we discussed in class. Okay. So let's go ahead and start reviewing our lectures. I want to start off basically giving a summary of each of our lectures and the main concepts we covered there, and then we'll follow that with a group of questions, basically two questions, a question from part 1, which is closed book, and a second question from part 2, which is going to be open book. This is going to be a sample of what you could see on the exam. So let's start off with our contracts overview. First, we start off talking about contracts and why we need to know them. We enter into contracts, their importance for the economy, and so on. And then we start going into classifications of contracts. So we started off with the classification of implied versus express contracts. We talked about the fact that express contracts are those who are manifested by, where we manifest assent either orally or in written words, and we also have those who are the second type, which is implied in fact, where we have assent manifested by our actions rather than our words. We also had a second classification of contracts, which is based on subject matter. We had different types of contracts that are based on the transactions. Each of those contracts, of course, is treated under law differently due to the different levels of protection offered to the different sides by law. We also talked about an important classification of bargain contracts versus contracts of adhesion. We talked about negotiated contracts, where we have two parties of equivalent bargaining power being able to enter into negotiations where there's give and take, and then they mutually agree on a satisfactory agreement or find a satisfactory agreement. Contracts of adhesion, on the other hand, have limited or no bargaining, and the dominant party basically hands a contract on a take it or leave it basis for the weaker party, and the weaker party has to accept all the parts, all the components of that contract. We also started talking about an important concept, which is the concept of mutual assent, which we defined as the meeting of the minds that's needed for creating a valid contract. Each party basically should be believe that they have entered into the contract, and the way we express this mutual assent is through something that we call offer and acceptance. The parties usually communicate this offer and acceptance either orally or in writing. There usually aren't any problems with expression of offer and acceptance if the parties are in the same location. However, if parties are at a distance, the offer and acceptance may need to be proven somehow. And then we needed to start to distinguish between an offer and a negotiation or a proposal method process. The main difference there, that an offer creates you something called the power of acceptance, where if you just go ahead and accept an offer, you have a valid agreement. We also talked about in mutual assent, we also talked about contracts by correspondence. We talked about what we call the mailbox rule, where the offeree would, if they use the same exact mode of communication, have the correct address and postage, would basically have their acceptance effective immediately once they place it in the mailbox or in that same means of correspondence. This rule only applies if the offer has not required that the communication be actually received. So sometimes offerers can make a statement in their offer saying that the offer has to be received by a certain date, and therefore in that case the mailbox rule may not be valid anymore. In mutual assent, we also talked about certainty of terms, because that will basically make it we can distinguish between a firm, clear offer and complete terms than the negotiation phase. And the certainty is needed for also allowing judges to determine the contract terms and what needs to be performed. The certainty of terms is, we actually use the standard of something called reasonableness there, where we actually are requiring reasonable certainty, which basically doesn't say that all the terms have to be completely clear. In mutual assent, we also talked about something called preliminaries, which is basically different types of writings, informal writings, or tentative writings, tentative agreements, or purchase orders, where people would expect more formal writing to follow. The question is this binding? And we basically started thinking about that, and the answer is that it depends on the intent of the parties and whether they were intending to be bound by it or not. But usually modern courts are trying to find contracts at the earliest convenience possible, as well as at the earliest possible time. I mean, if they're convinced that the intent to be bound exists. We also talked about something called agreements to agree, where basically you have people who agree that they basically have terms, they're going to leave out terms that they're going to agree upon in the future from their contract, and we basically had those agreements to agree are sometimes enforceable, and sometimes modern courts would enforce them by basically having them start talking about them again and stuff like that. Similarly, we also had the agreements to negotiate in good faith, and again there's a tendency to enforce those, and this is by again requiring the parties to negotiate in good faith. We also had something called letters of intent, which is again a possible manifestation of mutual assent, where one party would want a performance to start before a full agreement is reached, and they basically issue a letter of intent, just telling the other party how they would pay them for the work that they would be performing under this agreement to agree. We also had something called memorandum of understanding, which is not binding generally, because this is just a statement of kind of showing where people have reached in their negotiations. It indicates tentative agreement, and seeing so that people would also see what remains to be negotiated. And generally, if some of those agreed upon terms are open, sometimes that could be an indication of people not dealing in good faith. We talked about, after that, we talked about defects in mutual assent, and those defects in mutual assent included fraud and misrepresentation, which is one, and we talked about the fact that if misrepresentations were made with the intention, not with the intention to deceive, there could be either innocent or negligent. These are generally less morally reprehensible, and usually fewer remedies are given to the deceived parties. In case of negligence, the victim recovers damages to compensate loss. If it's innocent, the only thing that's likely is basically a relief or cancellation of the agreement. And then basically we also had other defects of mutual assent, including economic duress. So in the past we used to have something called physical duress, where we would have people being forced to enter into contracts by having someone basically point a gun at them and ask them to go ahead and sign a contract. Now it's more the case that people may enter into contracts under something called economic duress, which is a form of business compulsion or hard, excessive pressure beyond permissible bargaining, which actually could be construed as economic duress. It's been found in very few cases, and the hesitance in finding them in cases relates to the inherent pressures of the bargaining process, which may be misrepresented again or misinterpreted as a form of duress. We also talked about the doctrine of mistake, which is the doctrine most often used for attacking contracts. There are a number of possible types of mistakes. There are mistakes in the terms of the contract, mistakes that are caused by fraud or mistaken agreement, and mistakes in basic assumptions upon which the contract is based. Very few generalizations can be made, but in general, one of those few generalizations we can make is that the greater the carelessness, the less likely the party is to get relief. And the second generalization is that arguments of mistake by a party are more likely to be accepted if the other one is getting something for nothing. So remember, we talked about consideration. So lack of consideration could be again an indication of mistake there. Some of the other defects, one of the other important defects in mutual assent is unconscionability. And something to be unconscionable is that when it shocks the conscience of the judge. Many courts refuse to enforce contracts that are unconscionable, but it started under the Uniform Commercial Code (UCC) in Section 2-302 for the sale of goods, and that gave judges the power to strike out parts of contracts that are unconscionable, and this is gradually getting accepted in other forms of contracts as well. Another important issue under mutual assent is something called formation defects and restitution. In restitution, restitution is basically a remedy or where basically a judge or a court could confer benefits when a claim cannot be based on a valid contract. And there are two cases for that. One case is when there's no one we can have a valid contract with. So remember the example of the doctor who saw someone who passed out on the street, and they basically gave them some relief, and they helped them out as professionals, medical professionals. They can go ahead and bill them later. So even though that person who was basically unconscious at the time wasn't capable didn't have the capacity to enter into contract, but still they may be able to recover the cost of the service through restitution. Another case for restitution is when a party intended to make a contract but did not do so for any reason. So that is a very important concept. And we talked about also there, we started talking about an important concept, which is the concept of consideration as a contract requirement. One of the functions of consideration is that it distinguishes enforceable from non-enforceable contracts or promises in general, because not all promises are basically important. Some of them are less important than others, and they don't need to be enforceable under law. So one of the methods used by the law, or one of the doctrines used for determining which promises are enforceable, is that doctrine of consideration, where actually we have a concept again, which is in Latin, it says quid pro quo, which means that something has to be given for something. The early law or early cases required that that a benefit conferred by a promiser has to be in return for there has to be something that the promiser gets in return for the promise that they're making, or the commitment that they're making. Later decisions enforced promises where the promiser received no financial or pecuniary benefits, and some of those, like for example, included gift promises, for example, and for example, one of the things that replaced or made the consideration less important is the concept or the doctrine of reliance, where if, for example, you go ahead and promise a charitable organization some money and they act in reliance by like spending some of their own money in building something, or in preparing for the gift that you're giving them, then you basically can't back out because of this action of reliance. Another important thing that looked at in consideration as contract requirement is past consideration, and we said that usually promises motivated by benefits received in the past are not enforceable. Some states, however, allow you to do that in cases of debts that could have been discharged by bankruptcy or statutes of limitations. And then following that, we started talking about an important concept of promise under seal, which is again during the time before people were able to write, people used to have something called a seal, which is an impression that people made using some kind of a ring or other instrument in soft wax that's basically placed on paper. It basically emphasized the seriousness of the transaction and made the content of it enforceable. U.S. seals will start to be reduced to the word seal, or the abbreviation LS, which is Latin for something. And then many states now even deny the seal any function, but some states still have documents under seal enforceable with the presumption of consideration existing. Now, we followed that with also a discussion of something called the writing requirement and the statute of frauds. The statute of frauds is a law that was passed by the English Parliament in 1677, which requires something called a sufficient memorandum to be presented for specific transactions. The reason were actually twofold. First of all, to make sure that to protect litigants and courts from hearing claims that are of questionable merit or are dishonest, basically. The second reason was that it was used as a warning device for cautioning people from going into a transaction, just to make sure that they understand that it is a legal, serious legal obligation that they have to fulfill. The statute of frauds was adopted by most U.S. Jurisdictions, and it basically had a bunch of transactions that needed to be in writing, and there was a number of things we talked about following that, which is including we talked, for example, about something called the sufficiency of memorandum, where basically how do we deal with electronic transactions, how did UCC allow the writing requirement to be satisfied, and also we talked about the methods for avoiding that writing requirement. Okay guys, so this was basically our first lecture, which took us actually more than a lecture to cover, but this was kind of a breeze through it as a refresher for you. And the questions I want to ask you here are two questions. Let's see the question we're going to ask in part one. True or false? An offeror can revoke an offer at any time before the performance of the contract. Is that true or false? And the answer is that this is actually false, because an offeror can revoke an offer anytime before acceptance of the contract. But if of the offer, if the offer gets accepted, then it's too late, and they can't revoke their offer anymore. What they do, they can basically not perform, and they'll be in breach of contract after that. A second question, that's in part two. This is a sample of what you could see in part two as a question. How could an agreement to negotiate in good faith be enforced? And the answer to that is that an agreement to negotiate in good faith could be enforced by a court by requiring the parties to negotiate in good faith, or it basically can, if some performance has been done, it basically can award the party just that made the performance again the cost of their performance, or it can actually look in the future and see what would the negotiations in good faith would have resulted in, and it would basically put those parties at that position in the future. So if someone would have stood to gain some money, the court could assume that they would have made that money, and it would basically put that other party in that situation. Okay guys, so this was our first lecture, and now moving on to our next lecture, which talked about breach of contract. We wanted to talk about, in here we talked about a number of things. We talked about first damages and specific performance. We talked about the fact that judicial remedies for breach were actually threefold. We actually had money awards, where the judge or the court would require a party to make a money award to pay some money to the other side. We had something called specific order or specific performance, which basically where the court will basically require a party to do something in specific or to act in a specific way. And we also had something called an injunction, where we basically have the court order someone not to do something. So that's the opposite of specific performance, which is the injunction. We talked about the fact that that maybe a specific decree is more effective because it's a personal command by the judge, and it's more effective as a remedy, because if the party fails to comply with the judge's order, the defendant or the party that failed to do that could be brought to explain their non-performance. If the explanation wasn't satisfactory, they could be punished with a fine or imprisonment, because they could be held in contempt of court, basically. Most awards in construction have no specific performance, and mostly they have money awards. It's usually the case that's the adequate type of compensation. We also talked about the difference between compensation and punishment. The difference is that when we talk about compensation, it's actually a compensation for some kind of a damage that the party lost. Punishment is usually the case where we have one party acting in a way that is viewed as immoral. And common law basically didn't view breach of contract as an immoral act. Therefore, the damages awarded are usually for compensation for an actual loss, and they're usually not what we call punitive damages. And punitive damages are usually awarded in what we call cases of tortious breach, where the breach is also linked with tort, which is basically a breach of their other liabilities, such as extreme negligence or something on the part of one of the parties. But again, punitive damages have been rarely awarded in construction. We talked about in how judges look at the interests of parties. Judges basically look at three main interests that they need to protect. One is restitution, which is the most protected. It basically compensates parties for their actual losses or for actual cost or the value of their work. We talked about the difference between cost and value, and we also have another important protected interest, which is called reliance, which includes expenditures made before or during relying on the agreement. So if someone is told or promised a certain thing in an agreement and they acted before actually the agreement is made, or during the agreement is made, or they're relying on it, if they made any expenditures, then a protected interest, of course, we try to protect is their reliance, the money that they spent in reliance. The third protected interest is something that we call expectation, which basically is the position a defendant would have been in case of the execution. So if someone would have stand to gain $100,000 in profit, then again we try to award them those $100,000 in profit. That's the expectation there. Okay, there are a bunch of limits on recovery. So first, so the law limits recovery on a number of bases. These are rules for how people can recover on damages that they incurred for breach of contract if another side has breached the contract. One of them, the first one, is what we call causation, which basically that the claimant, person making the claim, has to show that the defendant's breach was the cause of the loss. So there has to be a cause and effect relationship. The loss may have been caused by multiple factors, but and it may be difficult to prove the amount of the loss caused, but by a certain condition or by other contributing factors. But it has to be shown that the loss is substantially caused by that breach of contract. So it doesn't need to be the only factor, but it has to be responsible for the majority of it. Another important limit on recovery is what we call certainty, and in this case the claimant has to prove that the loss, prove the extent of the loss with reasonable certainty. You can't be wavering there. You have to be exact and say that this is exactly how much we lost, and this again is governed by a measure of what we call reasonable certainty, which is based on opinion, evidence, and inferences that could be made. So we may not be able to exactly say it, but we have to exactly say how much we lost, but we have to come close or within reasonable or estimated with reasonable certainty. And then the third thing is how foreseeable were those losses, and the idea is that were the losses caused by something that was very improbable, or a combination of other large losses that led to this significant loss? Or could they have been reasonably foreseen by the party that caused the breach? So if they were not really foreseeable, it may be hard for us to ask them for relief, because they didn't know that they would be able to cause you that much damage. And we had an example of a case, again, case history that where again a certain delay was not foreseeable to cause that much damage. So, and also the fact that there was huge disparity between the value of the contract and the amount of the loss. So it definitely shows that that foreseeability is important. Another important limit is something called avoidable consequences, which is that a claimant cannot recover damages that they could have foreseen, had reasonably avoided. So you basically, in case someone breaches a contract and you can save yourself and not cause yourself to lose more money, then you should avoid losing that money as much as you can. A final limit is a limit on what we call lost profit. Claims for lost profit are usually governed by all the four preceding limitations. Some of the hurdles that you see in recovering lost profit is that first you have to show that if you've lost, for example, a contract that would have gotten you some profit, you have to show that this loss is due to the other party, or whether it's due to the other party's breach or for some other reason. How certain were the profits? And you want to show that the foreseeability of the loss of other contracts is this something that the breaching party would have been able to see, and or was this unforeseeable? And could the contract loss have been avoided or not? Could you have just went ahead and entered into that contract or not? So that's an important limit to talk about. The final limit here is the limit that we call the collateral source rule, which basically is a rule that denies the defendant to deduct any amount recovered from third parties if they are considered to be something called a collateral source. So, for example, if you had recovered money from an insurance company, that still means that the person who breached the contract is still liable for you for the amount of loss that you've incurred. They're not off the hook, basically. But through subrogation, of course, the insurance company will basically go ahead and go after that breaching party. But the idea is that collateral sources, if you recover some money from them, then basically the defendant in your case is still, or the breaching party in your case is still liable for the amount of money you lost. Finally, actually I misspoke, there's a final one, which is what we call contractual control, which is the fact that many remedies for breach sometimes are spelled out directly in the contract, and examples of those are, example, liquidated damages in construction contracts, and sometimes there may be language to protect parties again or limit their exposure. And basically the Uniform Commercial Code allows for parties to spell out their remedies for breach, but again does not preclude them from parties from going after more damages if the remedies in the contract were not sufficient. And then we also had the final limit, which is non-economic losses. They usually appear, non-economic losses, like for example loss of reputation, a loss of or emotional pain and distress and stuff like that. These are considered to be non-economic losses, and these are generally they could be tied to a contractual breach if the breach is linked to a tort claim. So it may include non-economic losses. Generally, the law does grant a recovery, but the problem is that even if the non-economic loss was foreseeable, it may have caused disproportionate compensation. So you basically may find that the value of the non-economic loss to be extremely high compared to the compensation offered in the contract itself. Okay, and then finally, one of the things that people would look at for recovery is the cost of the dispute resolution. In general, American law does not transfer prevailing party's attorney's fee to the other party because it's based on the reluctance to discourage people from using the legal system and courts. However, sometimes defective work claims based on deceptive trade practices lead to what we call expanded remedies. In some states, allow for something called reciprocal attorney fees, where you actually have, whenever one party is going to win, then they're going to have to pay the attorney fees for the other side. So, but it has to be reciprocal, not one paying for the others. And then finally, we want to talk about interest. Many states vary in their treatment of interest, claims for interest, prejudgment interest. So, for example, if someone is supposed to pay an amount and they're delayed a year in paying them, so is the other party entitled for interest or not? There are a bunch of requirements for interest to be paid or to be basically included as a remedy, and these include the following. First, the amount has to be easily determinable by computations based on standard contracts. So you basically have to be able to determine exactly the amount that should have been paid upon which interest is being calculated. Second, the party could have been able to avoid paying the interest by paying the amount due at the time it was claimed or requested. And finally, and which is basically leads to the third one, which is unless the amount is known, the payment cannot be made. So therefore, I mean, why would someone be liable for interest if the amount wasn't known? How much they need to pay was not known at the time. Local laws usually have to be consulted about this, because there are usually sometimes special rules for claims against public authorities in particular. Okay guys, this covers our second lecture for breach of contract, and the questions we have here, question number 1, which is, this is actually part 2. Which of the following is, actually this is part 1, this is a multiple choice question. Which of the following is a type of judicial remedy of breach? Money awards, specific performance, injunction, or all of the above? So it's obviously all of the above. This was pretty easy. And second, which of the 3 main types of judicial remedies to breach is the most effective? And remember, we said specific performance, and it was most effective because if someone did not perform, it's actually viewed as a personal order for that person or entity, and if they do not perform, they could be brought to stand in front of a judge, and they could be held in contempt of court, and special penalties and fines can be applied on them as well. Okay guys, so let's go ahead and look at our third lecture, which looks at our sources. We had 2 lectures on sources of rights and duties. The first one was sources of rights and duties from within the contract documents themselves. So we started looking at the different types of documents that we had within a contract. We basically had our bidding documents, and these bidding documents included they basically had your plans, your specifications, your general supplementary conditions. They had your invitations to bidders, information to bidders, and bid proposals. And then we also had the documents that are generated during the bidding process, included the plans, specifications, general supplementary conditions, addenda, agreement forms, and so on. We started talking about the basic agreement, which is basically similar to AIA A101, which is basically just it's a small document. The function of it is to identify parties. It talks about how the work is going to be performed, the time of commencement and completion, the sum of the contract sum, the amount of money that's to be paid, and the provisions for progress payment. For example, it's a small document, as I mentioned, and it usually incorporates by reference the other documents that are generated that we're going to talk about. And this is basically where the people find the dotted sign to basically sign. And then we had the second type of documents, which is our drawings, which is basically just a graphical depiction of the contract's obligations, and it basically is just the set of drawings that we talked about. And then the third one is specifications, and we spent some time talking about specifications because we had 3 main types of specification. One was design, and then the second was performance, and the third one was a purchase description. We talked about design specifications being basically a prescription or detailed specifications of, sometimes we also call them materials or methods materials and methods specifications, or detailed specifications. They tell the contractor exactly the measurements, the tolerances, the materials, the sequence. They basically explain in detail the material, its finish, and so on. So it basically prescribes what needs to be done. Performance, on the other hand, just talks about the performance characteristics of that final product, and talks about how it needs to work, and if the performance is met, basically the design and measurements are not really important. In this case, a contractor does accept the responsibility for design and engineering. Finally, purchase description specifications, they basically designate, or they tell the required products that need to be bought. Sometimes they basically tell the contractor to buy from an approved list, and sometimes this increases the cost of the work, because again, contractors can find alternate products, but in case where you need very specific products to be incorporated, then you want to go ahead and create this purchase description specification. Now, there is a relationship between specifications and labor union relations, and the reason is that many unions have created something called work preservation clauses with subcontractors, and this basically tries to decrease off-site assembly and increase on-site assembly. They may actually refuse to install components that have been pre-assembled in a factory, and basically this is something that's looked upon by something called the National Labor Relations Board, NLRB, and they govern that. They basically looked at. And then we basically started looking at a precedent case, an important precedent case, which is from Conlon Corp Italian versus Niagara Frontiers Transportation Authority. And remember, this was again for the construction for a twin subway tunnel 2 miles long as part of the Buffalo Light Rail transit system. There was a performance specification placing the responsibility on the contractor that the product, which is the tunnels, basically to perform as desired. In this, however, there was actually, and this was specifically talking about the water tightness of the tunnel, and it was viewed as a performance specification. However, when the contract was viewed as a whole, it created it created a design specification rather than a performance specification, because there were detailed specs for the lining, the concreting, how the fissure grouting was going to be done. The unit prices, there were unit prices provided for stem leaks. So of course, if you provide the unit price for stem leaks, it means that water tightness is not something that's guaranteed. You're going to follow certain requirements, and it could achieve the water tightness or not. And then also there were evidence that it's actually a design specification from parties' prior dealings, which is basically showing that the bidders had no input in design and so on. And then parties' dealings during construction also, the contractor was denied many requests for implementing other waterproofing methods, and they requested just to stick to the current specs. So basically, based on that, it was basically viewed as a design specification, and the contractor was not responsible for the leaks that were happening in the tunnel shaft. Another example, another important case was the case of Blake Construction versus the United States, where again Blake Construction was building a naval facility, and the drawings indicated overhead electric conduits. but there was a note that stated that the contractor can relocate conduits in order to coordinate with other trades. So Blake started putting conduits underground. The Navy said that no, you still need to put them overhead. Blake complied, and then they went ahead and made a claim for a constructive change order. The Federal Court of Claims agreed with Blake, but the Navy again appealed. Blake claimed at that point that the specifications were performance, allowing them to install underground or overground, or overhead, it didn't matter. The court stated, however, that made a very important statement there, which is saying that the defective design spec could actually be viewed as a performance one, but that doesn't give the contractor complete discretion. There is a distinction that the court made between the performance and design specification, and it said that distinction is not absolute. The court viewed that the claims court, which is the lower degree, gave too much discretion to Blake, and therefore they reversed that ruling of that lower court, which is the Federal Court of Claims. Then we moved on and started talking about conditions, general conditions and supplementary conditions. We talked about general conditions that are general, as they say, and they deal with many subjects, including scope, time, payments and completion, termination, disputes and insurance. And we basically saw an example of those general conditions when we looked at AIA 201, A201. We also made a distinction between something called between a general condition and something called a legal condition. A legal condition is basically something that needs to happen in order for another thing to happen. We talked about, like, for example, conditions precedent. So we wanted to make a distinction between those conditions and the conditions of the contract, which we call general and supplemental conditions. In supplemental conditions, we use those for customizing the general conditions, that are basically general, as the name states, and we basically put in specific information about how we're giving how we're basically addressing certain statutes or local laws or local requirements, and how we need to make modifications to those general conditions. The final thing we talked about is site subsurface conditions, and these basically are often included to the invitations to bidders, but sometimes they're not included as part of the contract documents. And we also talked about something called prior negotiations and the rule of that's called the parole of evidence rule. The parole of evidence rule says that a written agreement and the documents incorporated by reference are a complete agreement of the parties. Prior or contemporary oral agreements are not binding. So this basically cancels any oral agreements that were made before or during the final composition of that written agreement. So this was an important thing. We also talked about modifications versus changes. We talked about the fact that a change is something that happens during construction and is generally governed by provisions of the contract. We talked about modifications, on the other hand, which are changes that are agreed upon in the basic obligations of both parties, that are not based on any contract provisions, and basically create a contract of their own. And there we also talked about something called the pre-existing duty rule, which says that the contractor, for example, cannot get a price increase without giving something in return. So if they went into contract for building a two-story building for $100,000, they can't claim $110,000 without offering something extra to that building, Okay guys, so the questions we had here, basically this is a multiple choice question. Which of the following is not a function of the basic agreement? identify parties, define the time of commencement and completion, identify provisions for the progress of payments, or none of the above. So the answer is obviously none of the above. And a question I have for you guys here for part 2: what's the difference between incorporating documents by reference and a reference document? Remember guys, when we talked about incorporation by reference and reference documents, incorporation by reference is that we have a group of documents that we include as part of the contract, such as, for example, our general supplemental conditions. We also talk things such as our drawings and specifications. We incorporate those by reference. A reference document is something that we refer to within the document itself, such as a standard. For example, an ACI standard for concrete. We would consider that to be a reference document, rather than something we incorporate by reference in our document itself. Okay guys, so this covers lecture number 3. Now moving on to lecture number 4. I know this is a bit detailed, I hope you don't get bored. So let's go into lecture number 3, which talks about other sources of rights and duties. And here we are talking about what we call judicially employed terms, where the court is basically going to come in and imply terms for us, or start putting in terms for the contract on our behalf. And here we started talking about we talked about the necessity for implying terms, and we said that this happens because some matters are considered to be obvious to include, or sometimes matters are discussed and during negotiations but not resolved, and then people go into conflict, and the court has to basically start filling in the gaps for those parties. In the past, courts view themselves as enforcing contracts rather than creating them, but more modern courts are willing to start basically make contracts or fill in the gaps in contracts in general. And we talked about, in this case also, we talked about a group of obligations that could be employed, and they could be sometimes employed by the courts. One of them, for example, is the duty to cooperate between parties, which includes, for example, the duty to refrain from negative action, but also sometimes going further, there may be an employed obligation for requiring performance of certain positive actions that prevent the loss of others. But in general, we mentioned that the duty to cooperate should not be basically one that creates a heavy business burden on one of the parties. Other examples of implied promises that can be found by courts as they are applying terms of the contract, for example, include the owner's promise to make sites ready for the contractor, owner's promise to that the design professional will act reasonably. So this basically covered the possible types of implied terms that could be applied by courts, and also the need for implying them. Another important source for duties is basically custom, which could be used by courts for, again, filling gaps in contracts. And this basically covers customary practice that are used for many cases for determining the duties. So how do we do this usually within the industry, and how do we perform certain actions or do certain things? Many courts have emphasized this custom and customary practice in interpretation of contract language and trying to understand the actual intentions of parties. And sometimes contracting parties may be held to customs even though they are not aware of them, if they don't know them but should have known them, for example. Established customs sometimes is probably a very convenient method for trying to understand how people think and how to fill in the gaps. Another source, again, for implied terms is basically building laws. So contracts, both implied or express, either imply or express that the contractor will comply with building laws and land use controls, and when the design and construction process are separated, the design is usually the contractor's, the owner's responsibility. However, the contractor should not ignore the law and should direct the attention of the design professional if there is any violation of code or building laws. So another another important obligation is the obligation of good faith and fair dealing, which wasn't something that was common law used to hold as important in the past, because common law used to view written documents as sacred, as very important. Contracting parties were assumed to be capable of taking care of themselves, and the word good faith is really not precise. However, beginning the mid-20th century, American contract law started to reform, and it partly was influenced by the creation of the Uniform Commercial Code, the UCC. Parties were not, but as under good faith and good faith and fair dealing, parties were not expected to guarantee other parties to receive their expected benefit, but at least they were not they were expected not to make the other party were not expected to make unreasonable sacrifices, and also the parties were expected to avoid any deliberate and willful frustration of the other party's expectations. Some of the applications of this were of good faith and fair dealing is, for example, in how implied terms are being recognized. The terms that create good faith and fair dealing are the ones that are favored, of course. Unspoken objectives of the contract is also important. There were a couple of examples in your reading again of cases where good faith and fair dealing was a pivotal issue. These included Meyer Trucking versus United Construction, Scherer Construction versus Hedquist Construction. So I do encourage you to read those. And good faith and fair dealing. I mean, a method. How can you illustrate bad faith and fair dealing? It could be actually illustrated by, for example, showing that someone had the intent of making changes, and this is sometimes evaluated by trial courts. And good faith also could be illustrated by communication. For example, if an architect is refusing to certify payments, and they have to show that they're doing that for good reason, not just because they don't want to. And again, good faith in settlement processes, how duress could be used to avoid settlements, how prime contractors negotiating their subcontracts, and how the termination happened, for example, between the owner and the contractor. And then the final thing is, again, an extension of good faith and fair dealing, which is unconscionability. Again, common law did allow for contracting parties to decide the terms of their contracts, but UCC broadened the unconscionability doctrine, and it created the obligation of good faith and fair dealing, which limits the conduct of parties. The doctrine has been rarely used to invalidate clauses in construction cases, except for cases where there was an exculpation or indemnification clause, where someone is trying to get out of a risk or responsibility that they should be carried. And for example, one good example of that was a case of a subdivision purchase agreement that barred the parties from going to litigation, and basically set up special arbitration proceedings, so that that was viewed that particular clause was viewed as unconscionable and was stricken by court. And the doctrine is basically going to be more likely, it's going to be invoked more often probably in the future, increasingly invoked in the future. Okay guys, so let's go ahead and see questions from this lecture. First question: true or false, the contractor has to obtain all permits required for a building project? That's actually false. The specific permits that are required are usually stipulated in the contract, and they're usually contractor is usually responsible for the ones that have to do with the, 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 the operation of the building, such as building permits, occupancy permits and stuff like that, land use permits and land use zoning and requirements and stuff like that are usually the owner's responsibility. But in general, it's usually stated in the contract. Second, give an example of how bad faith could be illustrated in the actions of parties to a contract. We actually had a couple of examples. So, for example, if a party goes into a contract and we can establish that they had an intent to make changes in the contract even before they sign it, that could be a method of establishing that they were entering into the contract with bad faith. Our next lecture talked about contract interpretation, and it was one of our longer lectures where we talked about two types of interpretation. First is what we call the language interpretation of the contract. There we started talking about some of the rules of interpretation. We said that the basic objective of it of interpretation in general is to determine the intention of parties. And the questions that we need to examine are many, but they include, for example, how can we determine intention? What if one party knew the other party's intention? What if no particular intention exists, and so on. We had a bunch of rules that we used for interpretation. One of them is what we call the plain meaning rule, which is basically that interpretation should take into account basically the plain meaning of the it's actually a method for limiting the interpretation powers of judges and trial courts, and usually does not apply to arbitration, but it basically the judge there has to first determine if the words used had a plain meaning. If the plain meaning does exist and is applicable to this case, the judge cannot go beyond the document to determine what the party's intentions are. So if there's a plain meaning of the terms of the contract, the judge cannot go beyond that and explain or interpret it any further. The second rule was what we call the practical implementation rule, where we actually had the statements and acts of parties before the dispute may be actually used to indicate their interpretation of the language. So how people behaved, it could be an indication of the party of their intention. So examples include, so for example, if a contractor bills the owner for certain unit prices and the owner pays the bills, they basically indicate that the unit prices are correct and they accept them. So they can go back and say that there was an error in their interpretation of the unit prices. We had a group of rules that had names in Latin: expressio unius et exclusio alterius. This one basically says that the expression of one thing excludes others. So if a list of things does not include a specific item, it excludes it from relevance. So if we have a specific list of things and it excludes one item, that means that we're not taking it into consideration. The second one is justum generis, which states that the meaning of a general term is limited by the specific illustrations that accompany it. So anything not specifically mentioned could have to be of the sort. So if we say, for example, damages to crops, trees, and fences and premises, that does not, for example, include damages such as depreciation of the market value of something. So that's the example we use there, because it's too unrelated. Another rule is that the interpretation has to be reasonable, fair, and just. And we basically, although this rule basically does not give the court the power to rewrite language or prevent parties from agreeing to language that may not be reasonable, but it still basically allows them to interpret language that is ambiguous or unclear or requires an interpretation for the meaning that is more reasonable, fair, or just. Then the following rule is the rule that's called contra preferentum, which means against the one who puts it forward. So it then interprets ambiguous language against the party who selected the language or supplied it or made drafted the language. And then we talked about interpretation of standard forms of contract. So, for example, AIA contracts. So, how can we interpret them? We have a bunch of types of AIA documents. So, for example, the AIA standard agreement between owner and architect. This is a document that's viewed more to be swayed for the interests of the architect because it's drafted by AIA without consultation of owner organizations. So therefore, it could be basically interpreted more against the architects. There are cases where contract documents are basically viewed as more swayed towards the party or the other, again as a result of who drafted them. And sometimes we could actually use documents that interpret the document in order for us to, like for example, documents that have provide explanations of AIA. We can use them as evidence again of certain intentions of the parties or of the drafters of that document in case of any ambiguity. We also talked about a bunch of other interpretation questions. Sometimes we talked about the fact that courts look closely at the indemnification clauses, and of course, and we also asked what happens in errors of bidding documents, and the interpretation assumed is usually the interpretation of any reasonable, prudent bidder. So that's the one that's being sought. We had a case of Newsom versus the United States, where again this was a VA hospital improvement project that was being built, and there was a patent ambiguity there, which basically had where the contractor failed to consult the specifications of the contract for the construction, called for the construction of 3 buildings, and the drawings referred to a first and second floor in one of the buildings, but not others. So the caption for the first floor was included in all 3 buildings, while the second floor drawing was only included for the 3rd building only. The contractor later discovered that the owner just wanted the second floor on all of them, and they basically complied, but they made a claim for the extra cost, and that claim was denied by the VA Board of Contract Appeals because the ambiguity was patent, and it imposed a duty to inquire on the contractor. The patent ambiguity doctrine is basically one of those very few exceptions to the contra preferentum rule. So the duty to inquire is created if you face a patent ambiguity, and it prevents contractors from taking advantage of the government, basically. So that was the case, and so basically the decision of the Contract Appeals of the Board of Contract Appeals was affirmed. So they denied Newsom the claim because this was a patent ambiguity and created a duty on them to inquire. So, along with the language interpretation of the contract, we also have issues of sometimes resolving conflicts and inconsistencies within the contract document itself. So how do we resolve inconsistencies within a written agreement? So in general, contracts, courts would generally look at the interpretation of a contract as a whole. They wouldn't, and they would try to reconcile provisions of those contracts within each other, and then they basically would follow some rules, such as, for example, giving precedence of operative clauses, giving precedence to over those that give general background. Handwritten is sometimes preferred over written over printed. However, if the contract is printed by word processes specifically for this transaction, sometimes that does not apply. The priorities here that we talk about are just simply guidelines. There was a case here for a precedent case that we looked at closely, which is the case of Unicon Management Corp versus the United States, where this was actually a contract for the construction of a missile master facility near Pittsburgh, and the government refused a demand for equitable adjustment for steel plates on a floor not called for by the plans and specifications. The specification called for the entire concrete floor, while the drawings basically called for concrete and steel. So there was basically a disparity there. The specification had all concrete, while the drawings had concrete and steel. So the steel plates were in the drawings. The contractor did rely on a clause that states stated in the contract that in case of difference between drawings and specifications, the specifications shall govern. So this is what we call a precedence of documents clause. But the board did invoke a provision that says that anything mentioned in the specifications are not shown in the drawings, or shown in the drawings but not mentioned in the specifications shall be as effect and shown in both. The specification did call for all concrete, and the relevant drawings did show a different impression. The court did view the drawings as being supplementary to the specifications, but not contradictory. So the court did point to the view that the contractor should have been aware of the possible contradiction. So again, and the plaintiff in this case again was found not to be entitled to recover, because, and this was what we call a patent ambiguity, and the contractor was created a duty to inquire. There was another case that followed that we looked at, that took a different view on the issue of precedence of documents and the duty to inquire in cases of patent ambiguities. That was the case of Hensel Phelps versus the United States. So Hensel Phelps was in contract to build a jet engine repair facility in the Tinker Air Base, in Tinker Air Force Base, and the specs required an 18-inch fill, while the drawings called for a 36-inch fill. The contracting officer was advised that Hensel Phelps used the specs rather than the drawings in pricing their work, and there was an order of precedence clause that again gave higher precedence for the specifications over the drawings. But the contracting officer nevertheless directed Hensel Phelps to go ahead and build the 36 inches of fill. Hensel Phelps did, of course, comply, and they basically made a claim for constructive change order, and which was denied by the contracting officer. And then they went, of course, to the Board of Contract Appeals. And the board basically said that Hensel Phelps knew of the conflict during preparation, so they basically again had the duty to inquire, and the court. But however, in this case, the decision of the Board of Appeals was reversed by the Court of Appeals because they saw it as inconsistent with a precedent case called the Franchi case. The Franchi case stated that precedence of documents, if in case where we have a precedence of documents clause, this limits the obligation of the contractor to report a patent discrepancy or patent ambiguity. So in the end, that the Court of Appeals basically reversed the decision of the board, initially denying Hensel Phelps the claim, and it basically stated that the duty to inquire is basically not as important anymore in case if there is a precedence of documents clause, as long as the party is not overreaching, as long as, for example, Hensel Phelps in this case was not overreaching. And by overreaching, they're basically trying to grab some money from the contractor, from the owner extra. So basically, discrepancy between the documents, between different documents. So we looked at the cases of, for example, we had discrepancy between between what happens if we have a discrepancy between specs and drawings. So which one will govern? So that we talked about the fact that if we have a patent ambiguity, then there's a duty to inquire, and then the duty to inquire was limited by Hansel and Phelps case, because again, the contractor should reasonably rely on the presence of documents clause. Now we're talking about what happens if there's an inconsistency within a single document itself. So the inconsistencies within a single documents, well, actually, that's still between documents. Sorry. So we're talking about, for example, AIA, but there are many arguments that one can make against including presence of documents. So in general, including the presence of documents clause has a bunch of problems. The first is, for example, which one should be included, which one should be given higher precedence. There are so many. The presence of documents clause will not deal with problems of evidence for low-ranked documents, for example. So, I mean, what happens if we mess up and choose the wrong documents to have high precedence? So that's why we should probably avoid including a presence of documents clause in general. Another important topic we talked about is something called reformation of contracts. This is a remedy that's granted by a type of judges we call equity judges, and they basically try to rewrite an agreement to make it conform to the actual agreement of the parties. And equity cases, they basically don't have juries, so the courts are usually freer. The reformation, most cases basically involve things such as improper description of land in a deed, but sometimes there were cases where there were mistakes. There were also reformation in cases of mutual mistake. So there was this case of National Presto versus the United States. This particular case was for the construction. It was basically creating. This was what we call a joint enterprise experimental situation, where the government was really interested in the process of creating the product rather than the product itself. So therefore, courts of claims basically looked at this case, and they basically decided that the reformation of contracts is basically should be justified. It's mostly justified in cases of joint enterprise in experimental situations where neither party assumed a particular risk, and the interest of the government, we're talking about federal procurement here, where the interest of the government is in the process, not just in the product itself. So this was the topic of reformation of contracts, and the questions we have here from part 1: true or false, judges and juries have absolute freedom to determine the meaning of contract terms, and the answer here is false. And explain the plain meaning rule. So I need you here to for example, say that the plain meaning rule says that a judge, if there a plain meaning plain meaning exists for the language of the contract, the courts cannot go beyond that plain meaning in interpreting the intention of the parties. So this is all I needed you guys to say here in that particular question. Okay guys, moving on, we now move into AIA. So just as a quick reminder, AIA 101 had 10 articles. You see the list of them here. We went over them in detail, Mr. Jones did, and we went through many questions and answers about them. You guys have a listing of them. These questions and answers are good candidates for questions in part 2, so you definitely are encouraged for looking at them in detail. And I have a question for you here that's true or false. So it's true or false: bidding requirements are always part of the contract documents. No, they're not always. So the answer is false. They would be if they're enumerated later on in Article 9, enumeration of contract documents. So that would be the only case where they'd be included. What is the application of for payment? What will the application of payment indicate? So you guys can definitely, in this case this is open book, so you basically want to go to look at application for payment. Application of payment will basically indicate percent complete and which portions of the work are complete, and so on and so on. And so basically we want to go ahead and talk about the things that you see in that particular part of the contract document. And then 15 articles of AIA 2.1. You see all of them here. You guys have access, you will have access to the document, so please bring it. It's expected that you would. And the questions I have for you here: true or false? According to AIA 2.1, A21 2007, the contractor generally has the right to stop work pending the final resolution of claim. This is actually false, because they basically can't stop work pending the resolution of claim. They only can stop work if they're not paid, or if the owner basically just delayed the work, kept on stopping the work beyond a certain limit of time that you can see in the termination of the contract. Why does the contract state that time is of the essence? We had an answer. We actually answered that question in class, because it basically, if you don't state it as of the essence, it will not be something enforceable. You won't be able to basically hold the contractor liable for it if they don't go ahead and execute things in time. Okay guys, so this is all I had for you by way of a revision. I hope this was useful. Please go ahead and make your readings and bring your the things you need for your open book exam, and of course, work smart, don't work hard. The exam is gonna need you to work diligently and know where your stuff is. So basically, make sure that you study. Don't just rely on the fact that it's open book. Anyways, best of luck. If you have any questions, please shoot me an email, and I'll try to see you guys online maybe tomorrow or something actually on Monday, but I'm not positive yet. I may be actually going around somewhere, so I may not be able to go ahead and go online. But anyways, best of luck with your exam, and if you guys need any help, any further help, please do shoot me an email. Okay, bye.